Perfect. So, Ms. Pugh, Mr. Jeffries has been appointed to represent you. He's just been given, he's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of the appointed court agents, considering that their first duty is to the state.
I understand. We've had this conversation before.
And for the record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today if that's what you want to do. We'll get your case set for trial and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here's what happens. When you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of things couple of options, and we'll go over those as well. Okay. So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you?
I know been accused of.
Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud just for the record.
Do I understand? No, I don't understand.
What do you not understand about that?
I don't understand, Your Honor.
So here's the thing. If you want to represent yourself by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I haven't did anything wrong.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine, after they listen to the evidence, if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case. I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff. Go back with the bailiff. Welcome to the criminal appointment list.
Yeah, fun, Judge.
This was not meant to be any kind of punishment, I promise. So we'll do, so Mr. Jeffries, just, I mean, get ready like you would. Probably it's going to go straight onto a jury.
Right, I would
And
assume.
we'll just get it figured out that way. All right.
My name is Eric Jones. Eric Harris. All right, what are we doing now?
Your Honor, we have two matters up. I have prepared and signed a request for screening into the 15th District Mental Health Court. Actually, I need to absolutely.
And how long is that taking, you think?
Your Honor, they meet every other Wednesday, so maybe 3 to 4 weeks.
3 weeks.
They just met. Yes, I attended. It was yesterday.
Probable cause conference, October 31st, 2024, 9 a.m.
Your Honor, the court received a report from community corrections that indicates the defendant was testing at Ann Arbor Treatment Center has had positives at that facility. I think the report was dated October 1.
I have that. He actually has a bond out. He actually has a warrant out at this point.
Your Honor, if I may address that.
Go ahead.
Your Honor, Mr. Harris, there was the testing information. He came to my office on Monday morning. We discussed the matter with, or Tuesday morning, I can't remember now. We discussed the matter with his provider at the treatment center. He informed us that Mr. Harris is prescribed methadone and it's provided for him there. He also said that he had provided a new test to Community Corrections that was dated October 9th, I believe, that or October 7th, that was clean for things that he was not prescribed for. And I reached out to the agent and to see if he had the test, and he hadn't. I believe Mr. Harris would, if the court wanted to test him today, would likely come back negative. I'd ask the court to consider.
He'd come back negative today?
Yes, except for, I think, for the what is it called? Methadone. Sorry, Judge. But in talking to his agent there, I guess in certain circumstances, fentanyl can stay in your system for some time. But I believe he's had a negative test recently for fentanyl that his agent advised that he had sent over to Community Corrections. Yes, Judge, I have seen those, and I believe there's an October a more recent test than that is negative.
And Your Honor, I do believe that people have received the same documentation. This is not a format that I am personally accustomed to receive drug results in. However, it is my understanding that it indicates the positive urinalysis on the 9th, November 10th, November 18th, November 26th, each for methamphetamine. There also could be positive tests from
Yeah.
the methadone is a separate test, which is under here as MTAB versus MTAB, I believe. I believe MTAB indicates methamphetamine. My best understanding, it may or may not, but the MTAB is what I believe indicates methadone. I believe that's different.
It is.
And then I also see, if I'm reading this correctly, positive fentanyl tests from 8/28, 9/9, 9/10,
Yes, sir, I will.
negative on 9/18.
Let's hit it down.
Which is interesting, and then positive on 9/18.
Your Honor, if I might, I believe the meth portion is methadone, the MTAB, and speaking to Kenneth Hammond from the treatment facility, the meth is methadone and the MTAB is a metabolite, and the fentanyl is, well, fentanyl. That's my
Okay.
understanding from speaking to him.
But why is fentanyl showing up?
Your Honor, that Mr. Harris Jones is currently on tether. He is working to maintain sobriety. I believe his latest test, where we did, and Mr. Hammond said he sent it over to Community Corrections. I can call and see. I had hoped the court would have it. Was negative. He reported that to me earlier.
Right, but all that's going to tell me is that he's periodically using. because the one before that on the 18th is negative regarding fentanyl, but then the 26th is positive.
Can I speak, Your Honor?
If you want to.
Yeah, never mind.
Yeah.
Okay, I'm not using periodically though.
Pardon?
I'm not using periodically. That was just, never mind. Go ahead. Never mind. Go ahead. All right.
Your Honor, as I said, he is in a program. He is, I believe he is endeavoring to work his hardest at it. His latest test would be negative. I'd ask the court to consider, admonishing him not to use to continue testing and to, stay within the parameters of the, treatment program that he's involved in currently. He has several things going for him. He does have a meeting next, Tuesday on the 15th at 3:00 with Community Mental Health. He's been going through their screening process. This is with the housing people.
Okay.
Um,
I don't have a problem with any of that. But what I'm going to do at this time, I'm going to remand the defendant $25,000 cash surety bond on each case, which was the bench warrants that I set. And then once he is looked at by the folks at, I will reconsider that. I don't have a problem doing that, but there doesn't seem to be much that's kind of holding him in at this point, and that's what concerns me.
Thank you, Your Honor.
I'll set it for the 31st at 9 a.m.
Thank you.
Thank you all so very much for watching to the end. Please subscribe and drop a like if indeed you did enjoy. I hope so. Until the next time, I'm off to feed those cats. And if you want to see another cool episode of mine without all the mandatory stuff, then click on the episode on screen now.